Bay. So in all of my dealings with him, that's what I refer to him as in the briefs and in all the documents before this court. His name is Andre Perkins. So if I say Afon Bay, I mean Andre Perkins and vice versa. So in case I mix up on that, just know that I'm talking about Mr. Perkins. In this case, we have raised two issues. The first was the trial court's error in denying Mr. Perkins his request to represent himself in this matter, and the second issue deals with the trial court's denial of his appointed counsel's request for a continuance the day before trial. For the purposes of argument, I'm only going to focus on that first issue, but if there are any questions about the second one, I'm happy to address any of those. To the first issue, the right to self-representation is grounded in the Sixth Amendment, and the main idea behind that is that a criminal defendant must
Mr. Raines, can you help me before we get into the standards?
Yes, Your Honor.
When do you contend the denial of counsel actually occurred? Or excuse me, not the denial of counsel, the denial of the right to self-representation actually occurred?
It first occurred on September the 8th.
Okay, that's at right after the arraignment?
No. So I've got a timeline, and that may kind of help as well.
Okay. Is that, as I understood it, there was a request made at or about the time of the arraignment. May have been a request, can't tell, maybe the day before trial, and a request the day of trial?
So the first request that Mr. Perkins ever makes to represent himself is at arraignment.
Okay.
It is a different trial court that handles that. It's Judge Wolf who handles that.
Do you contend that that is a denial of the right to self-representation at all?
That judge allowed Mr. Perkins to represent himself.
Okay.
I do acknowledge that that trial court judge did not mention any of the Smith factors, didn't follow anything that looks like a procedure laid out in Rule 44, but still allowed Mr. Perkins to represent himself.
It's fair to say, though, at that point, at the arraignment, that no constitutional waiver of anything had taken place. There hadn't been a waiver to right to counsel. There hadn't been a waiver to proceed pro se at that point.
I would agree with that, because Mr. Perkins, at every opportunity, expressed his interest to represent himself.
How would you characterize the trial courts, be it Judge Wolf or Judge Lockhart-Mash, how would you characterize their ability to be able to successfully communicate with your client?
I think that ultimately the record bears out that they were able to successfully communicate with Mr. Perkins. I acknowledge that Mr. Perkins, as a pro se litigant and as an untrained individual representing himself in court, was fixated on the issue of jurisdiction, and that he brought that up at multiple instances, but that did not affect his request to represent himself, and to say that a denial should be grounded in that, I think would be impermissible. I recognize, and the case law is replete with this, that it is not a good idea to represent yourself. The Smith factors, most of them are geared towards full stop saying it is a bad idea for you to represent yourself. Have you considered X, Y, and Z in that scope? And here we have a little bit of that from Judge Lockhart-Mash at the September 8th hearing, but we don't have a full continuance of that, which is, in light of that, or within that context, you still wish to represent yourself.
So is September, help me with this, if I can go back just one more time, please. What is the date, what is the time where you contend there was a violation of the right to self-representation?
That would be on, the first instance would be on September the 8th. That is when the trial court addresses Mr. Perkins about him representing himself. Up until that point, he had been allowed to represent himself.
So he's assigned counsel at that point.
Yes.
Fast forward to trial then on March 7.
Yes.
Okay, is he denied his right to self-representation on March 7?
Yes. Well, on March 7th, I believe that was a plea cutoff hearing. Okay. I think that at the March, I'd have to look at the record again, but I think at the March 7th hearing, it was very short. Trial counsel told the judge, basically, I have not been able to speak with Mr. Perkins other than maybe a little bit out in the hall. That's cut short. Trial judge says, you will be at counsel table tomorrow. We're going to trial. And then on March 8th of 2022, which is the trial date, again, trial counsel says, Mr. Perkins is telling me he wants to represent himself. So the first violation, if you want to look at it that way, would
What's
be
the operative
on,
violation?
pardon?
Is there an operative violation? I mean, is there, I guess what I'm trying to get to is, so if I look at the traditional factors, is it a timely assertion, for example? I'm trying to figure out, is the March 8th the timely assertion or the untimely assertion? Do we measure it sometime before then, back in September?
I think in this context,
he didn't raise the issue again until trial.
I think in this context, you can view the entire record as it exists for timeliness. And the state had, in their brief, only contested the third factor, which is a knowing and intelligent invocation of the right. But as for timeliness, I think you can look at the entire record there. And we have the first time that he asked to represent himself as at arraignment on November 23rd of 2020. Then again on March 8th, there is a hearing that takes place. Mr. Perkins represented himself. At this point, we are now on to Judge Lockhart Mash, who allows Mr. Perkins to continue to represent himself. On September 7th, we have a plea cutoff hearing. Again, Mr. Perkins is representing himself. The judge allows him to do so and says we'll continue to trial the next day. And then on September 8th is the first time that the judge raises the issue of, well, the original judge at arraignment didn't go over all of your rights and admonishments with you, so now I'm going to do that. And she falls short of doing a full inquiry into that issue and just basically says, you do not understand the laws as they work in this courtroom. And I find in the motion for new trial, she said I deemed him incompetent, basically, to represent himself. I'm going to appoint counsel. And then again, you have at least on March 8th, on the actual trial date, you have
Can
Mr.
we
Perkins
pause
saying
on
again, I want to represent myself.
Can we pause a little bit on the September 8th date, though, that you were just talking about?
Yes,
because
sure.
I think a prudent decision by the trial court at that time is like, hey, we have this big issue hanging out here. We need to discuss it in more detail at this point. And I hear how you're characterizing that conversation, and I think that's certainly one way that a good advocate would characterize the conversation. Couldn't it also be said at that point, though, that the defendant was, while being a lot more responsive than he had been in prior court dates, was still not responding directly to the questions that were being asked by the trial court, and at some point seemed to equivocate on whether he actually wanted counsel or not, referring, it seemed to be, to his preliminary hearing, where it's hard to hear exactly what he's saying there, but it seems like he thought it might have been helpful for him to have a lawyer at that stage.
Your Honor, I would respectfully disagree with that. And the state has, in their brief, made a lot to do about the fact that Mr. Perkins asked for mercy during this exchange with the trial court. Firstly, there is a back and forth that takes place between the trial judge and Mr. Perkins, where it's, have you studied the laws of this state? Yes, I've studied the Constitution. Are you familiar with criminal procedure? Yes. So there's an exchange back and forth about that. At a certain part, it does get away from that. And as to any request for an attorney, the transcript hearing is in the record. And I addressed this in the reply brief. Within context, this request for mercy is not, I need help. Right? It's not, I need someone to stand here and either represent me or to help me represent myself.
He wanted to cut a deal.
Exactly. That's exactly what it was. And that is something that is commonplace for criminal defense attorneys. Mr. Perkins did it at an inopportune time, that he was standing at a lectern in open court, but to request for a plea bargain, I don't think is the same or can be equated to, I need representation.
What hearing was he talking about? Was it a preliminary hearing? Was it a pretrial litigation hearing of some sort?
I would have to look back at the record to know what it is that you're referring to there. That doesn't strike me as something that jumped out of the record, that he was referring to a hearing at that point. So unfortunately, I don't know.
Okay.
He did bring up time and time again that the trial court didn't have jurisdiction. And that's a baseline element that has to be proven in every case as jurisdiction. That, I would also note, though, I don't believe was addressed at any point with any specificity until I think it was the sentencing hearing. At the end of the sentencing hearing, the judge sat down and said, well, we have these types of jurisdiction. This is why the court has jurisdiction over you, that sort of thing. So I would say, I would just also note that, I guess, for the court.
So you're saying that by the end of that hearing on September 8th, that he was still making a clear and unequivocal request to represent himself?
Yes, Your Honor. Okay. And the reason why that there's no finality on that issue, right, within the context of, well, he asked for mercy, he asked for a plea bargain, that's not the same as asking for an attorney. The end of the Smith factors, if the trial court had continued along and addressed all the Smith factors as they go, they get very pointed to, within the context of everything we just talked about. You know, the judge said, I can sentence you up to 10 years in prison if you are convicted of this, right, if I stack them all up on you. But there was never a question of, do you want to represent yourself? Do you want an attorney? Those two basic questions were never asked. And everything else indicates that Mr. Perkins wanted to represent himself, because it comes up time and time again in the record. Initially at arraignment, that's one of the first things he says, I want to represent myself. At each hearing that takes place prior to September 8th, he's either representing himself or asked if he will and allowed to continue. And it's not until the September 8th date that is ended. And our contention is that it was done improperly.
So let me ask you this. In listening to your argument today, help me understand what your remedy is, because you say he's been denied his right to self-representation, but you also make several statements about how the trial court did make all the proper findings. So are we sending this back for the trial court to do a proper hearing on whether he should be able to represent himself? Or are we sending it back just for a new trial and allowing him to represent himself?
Yes, Your Honor. The denial of a request to represent oneself is a structural constitutional issue. So the only remedy for that is remand for a new trial. And that's what we're asking here. We don't need, there can be a part on a remand where, again, if he invokes his right to self-representation, this hearing can take place, these factors can be brought up. If he wants to represent himself and the trial court makes the proper findings that he shouldn't be allowed to do so, then counsel could be appointed over his objection. But the only remedy that this court has at this stage is to vacate his conviction and remand for a new trial.
What effect does the March 8th discussion have on this at all? So if I'm understanding the argument, and you'll forgive me, I'm still trying to figure out the point at which you say the constitutional violation occurred. And it seems to me that you're saying that occurred on September 8th.
Yes, Your Honor.
Okay, all right. If the trial court then denies the right to self-representation at another later time, and that denial is proper, just for hypothetical sake, does that cure the previous violation?
If there had ever been a proper denial of the right to represent oneself, where the Smith factors are at least somewhat followed, and it's obvious that it's a clear invocation, all of these things, then I think that, yes, that would cure any defect.
Okay,
I look at this as a
what happened on March 8th then?
On March 8th? The trial counsel said, Your Honor, my client's telling me he still wants to represent himself, and the judge says, I've already addressed that issue. I'm not going to take it up. And we move on. So
had the court addressed the issue on March 8th, went through the Smith factors, got the waiver, the right to counsel in writing, at that point there would have been no continuing constitutional violation. Is that correct?
I believe so.
All right. So is the real denial of the right to counsel then on March 8th, and that's what we need to be looking at?
No, Your Honor. I don't think that you can look at just March 8th for that. The way that I understand this, or the way that I have approached this, it is a continuing violation because Mr. Perkins is continuing to assert his right to self-representation. So it's not that each individual instance is in isolation, right? We look at them all throughout the scope of this case and as they appear in the record. And it's constant and continuous that Mr. Perkins says, I want to represent myself. I want to represent myself. And that the trial court allows that in part and then eventually denies.
There's
and then
no
denies
further,
again.
Between September 8th and March 8th, there's no assertion of the right to self-representation. Is that correct?
The only other court appearance, as far as I can tell, was on March 7th of 2022, which was a plea cutoff. And I'll be honest, I don't remember if the right to self-representation was made at that point. That was the first time that Mr. Perkins appeared with counsel.
There's no pro se motion that's filed that we'll see sometimes in these cases?
No, Your Honor.
Okay.
And I don't think that those are required in this case to show that it was a timely invocation of the right, because like I said, from the beginning, from November 23rd of 2020, Mr. Perkins is asserting his right to self-representation. And at each subsequent hearing up until September 8th of 2021, he is either allowed to represent himself or the trial court acknowledges that he is in fact representing himself. If there are no further questions on that issue, I'll reserve the remainder of my time for rebuttal.
Thank you.
Thank you.
Good morning, and may it please the court, Caroline Weldon on behalf of the state. This court should affirm the judgments of the trial court because the trial court properly appointed counsel. As Your Honor noted, there are 3 essential prerequisites that must be satisfied before a defendant may represent himself. The request must be timely asserted, it must be clear and unequivocal, and it must reflect a knowing and intelligent waiver of the right to counsel. Here, as counsel noted, there is no dispute that the defendant timely asserted his desire to represent himself when he was arraigned. He maintained that desire at 2 subsequent status dates, and it appears that the trial court allowed him to continue to represent himself on those 2 dates. However, at the day before his initial trial date, the judge decided that it needed to canvass whether or not the defendant really understood the nature of what he was waiving. The trial court noted that the defendant, in addition to these back and forths in front of the trial court, had also filed a series of pretrial motions that he describes as affidavits that, in the trial court's view, demonstrated that he had a lack of understanding about the legal system as a whole. Those affidavits or motions don't appear in the appellate record, but they indicated to the trial court that something might be amiss with the defendant's understanding of what he was waiving. So the day before the defendant's first trial date, the September 8th, 2021 date, the trial court asked the defendant a series of questions, the Smith warnings, in accordance with our rules of criminal procedure and Tennessee case law. As counsel points out, the trial court does not get very far in asking the defendant these series of questions because the defendant seems to have cold feet, for lack of a better expression, and says that he realizes that he does have a family and children, which I really can't jeopardize. He also mentions these affidavits or pretrial motions that he filed and expresses concern about why no one has responded to him. And finally, he asked the trial court for mercy.
But why can't, as the defendant pointed out, that his recognition of, I have a family, I need mercy, no one's responded to my motions, why isn't that just a request for, hey, I filed stuff and no one's responded, which would be a legitimate question to ask. And then 2, after thinking about my family and my life situation, I need to plea, even though we've had the plea cutoff. Why does that all of a sudden mean he can't represent himself?
Well, beginning with your question about why doesn't this constitute a plea, the defendant gives no indication that he intends to plead guilty. It seems like he's asking the court to assist him in his advocacy, which the court is not permitted to do. The defendant, if he's saying that he can represent himself as his own attorney, he would be responsible for being able to convey his wishes to the court.
I think what Judge Dyer may be asking you, and not to put words into his mouth, but you had started off the argument by saying essentially September 8th was equivocal because we have, it looks like he requested counsel, but then he kind of backed down. He was getting cold feet, is what you were saying. Judge Dyer, I think, was probing that and saying, why are we assuming that's the case? I think I would follow up with it, maybe with the question, what did the trial court do to determine then whether he was getting cold feet? That would be part of the Smith colloquy, right?
Yes, Your Honor.
So why are we assuming that he's getting cold feet as to something else? I think maybe, not to put words in his mouth, but I think that's what Judge Dyer was asking you. Why are you making an assumption about what's going on inside the mind of the defendant?
That's exactly the question. I mean, when he says, I have mercy, I need mercy, I mean, did the trial court inquire as to what do you mean by that? or anything like that, or did the trial court just let that statement sit there?
That exchange was after the trial court asked the defendant about whether or not he understood that he could be facing a significant sentence in prison. And so again, the defendant expresses no request for a lighter sentence or something.
Sure he did. He said, I need mercy.
I think in the context of the record, as I read it, it seems that he's asking the court for help and saying, I don't want to risk this prison
Well,
sentence.
so back to Judge Greenholt's question, we're all assuming what the defendant meant. Defense is assuming the defendant, when he said, I want mercy, is I need a plea deal. The state is assuming that when the defendant said, I want mercy, he's saying he needs help. And Judge Greenholt's much more articulate question than mine was, what did the trial court do to determine what he meant by, I want mercy?
The trial court interpreted that to mean that he needed the assistance of an attorney who could then advise him about, here are options about entering a plea of guilty.
Is that what the trial court stated on the record, or did the trial court just? That's my question. Is what did the trial court do when the defendant said that? Did he or she probe what that meant, or did they just keep going?
Once the defendant said that, the trial court stopped questioning the defendant and said, let's have you talk to a lawyer. And that's exactly what happened. And the defendant expressed gratitude for being equipped with a lawyer. And then after the attorney was appointed, he had 6 months to confer with him about his range of choices, about if he really didn't mean mercy in that way, if he really didn't want to have an attorney. It doesn't appear that he filed anything subsequently to the appointment of that attorney saying, I misstepped and actually I still do want to represent myself. There's nothing in the record to that effect.
Okay, do you agree that the trial court could not have denied the defendant his right to self-representation simply because the defendant lacked legal knowledge?
Absolutely.
Okay.
And
Do you also agree that the trial court could not have denied the defendant the right to self-representation simply because he didn't have the skills or experience of a lawyer?
correct.
And you agree that just because he didn't possess basic knowledge about trial practice and procedure, that also would not have been a valid basis upon which to deny the right to self-representation?
Absolutely. That would not have been.
If there is a denial of the right to self-representation on September 8, do we remand the case?
If this court felt that the trial court didn't thoroughly canvass what the defendant meant on that date, then yes.
And I'm not suggesting that the trial court did or did not, but if you assume that the trial court did not engage in a proper colloquy, denied the right to self-representation after not having engaged in the proper colloquy, had effectively denied the defendant's right to self-representation on September 8, is the remedy a remand for a new trial?
Yes, Your Honor.
Okay. Let's assume, and to play it one step further, let's assume that the right to self-representation was properly denied on September 8. How does the March 8th hearing impact that? There's no colloquy on March 8th. There's no investigation of the defendant's competency on March 8th. There's no colloquy. There's just a denial. So even if it's proper on September 8, how is the denial on March 8 proper?
I would not characterize what happened on March 8th as a denial of self-representation. I think it's important to look at the timeline of these dates in order. So on September 8th, the defendant is unable to show the trial court that he knowingly and intelligently understands what he's waiving. He then has 6 months until March 7th, so again, another day before trial sort of status date, where the defendant, it's a very brief date, as counsel noted, or very brief appearance in court before the defendant is removed from the courtroom. And during that time, he seems to express displeasure with the attorney that's been appointed to represent him. But I don't believe that he attempts to assert that he wants to represent himself. It's more of a disagreement with that attorney.
But on March 8th, though, when they come back for the day of trial, and I'm taking off the table because the parties have taken it off the table that there could be a timeliness issue, so I'm removing that. So when we come into the first day of trial on March 8th, counsel says, my client wishes to represent himself. And there's no colloquy at all that the trial court engages in at that point.
That's true, Your Honor. The trial court doesn't revisit the issue. I think, again, given the context of what the defendant represented September 8th, and then again the day before that March 8th trial date.
So even if in September, the trial court believed in good faith that the defendant was not capable of waiving the right to counsel and asserting the right to self-representation, didn't the trial court have an independent duty then on March 8, when it was confronted with a new request, assuming it to be timely, a new request to represent himself? Didn't the trial court at that point have the obligation to engage in a new colloquy and not rely upon something that had happened 6 months earlier?
Again, I don't think that the context of all of these court dates together and the defendant's behavior in the courtroom on these 3 particular dates in court show that the trial court should have done anything differently on the March 8th date.
Okay, so no colloquy was required on March 8th simply because of what happened 6 months previous?
I don't believe so. And again, just looking at the exchange that trial counsel was a part of on the March 8th date, I don't think him saying that I haven't been able to really communicate with my client or saying that I can't remember the exact words that counsel used on that court date, but it didn't give rise to the trial court saying we need to have another hearing on this particular issue.
Would anything have given rise to that? So let's assume, just for sake of argument, that the trial court properly denied the right to self-representation in September. Does the trial court have any obligation ever again to hold a hearing to revisit the issue about whether that was a correct, or whether the defendant can validly waive the right to counsel in the future?
I think that it could, but that was not the situation here.
All right, so when the defendant then comes back into court and through counsel says, I want to represent myself, I wish to represent myself, the trial court at that point has no obligation any further?
Again, not from the exchange. It was maybe a few sentences exchanged between trial counsel and the trial court on that March 8th court date.
Okay, and the trial court had the court itself, not counsel, but the court itself had no obligation to engage with the defendant personally any further to determine the extent to which the defendant wished to waive the right to counsel, to the extent that the defendant was capable of asserting the right to self-representation. There was no obligation?
I don't think so, Your Honor, not based on this ongoing communication with this particular litigant.
And so that I understand the state's argument, that's only because of the inadequate colloquy that occurred in September. Is that right?
I think based on the nature of the back and forth in September and what the defendant relayed, that the trial court at that point would have been very hesitant to allow the defendant to represent himself. And I think, frankly, that would have been the issue that would have been raised at this juncture had he been convicted, had he represented himself, is that they would have then gone back to September 8th and looked to that exchange and said he clearly wasn't able to represent.
I guess we'll never know.
That's correct, Your Honor.
Okay. No, that's fair. Thank you.
If there are no further questions, we'd ask this court to affirm the judgment of the trial court.
Thank you.
Thank you.
Thank you, Your Honors. Judge Greenholtz, just to quickly try and address your question, if you're separating out the September 8th and the March 8th invocations of the right and not seeing that as a continuous event, then I first say that the September 8th invocation was improperly denied because the trial court did not base its decision in a proper basis. It ultimately concluded that Mr. Perkins could not represent himself because he didn't have the technical legal expertise that you get by going to law school, being engaged in criminal defense, those sorts of things. On March 8th, I would also accept the state's concession that if we're not looking at timing or a clear and unequivocal invocation, that is still an improper denial. Because again, the trial court didn't make any findings at that point, just said, I've already addressed that issue, I'm not going to take it up again, we're moving forward. So I think under either of those, this court could find that Mr. Perkins was improperly denied his request. I think that the stronger one in this case is quite honestly the September 8th, even given the back and forth exchange with the trial court. Viewing the record as a whole, particularly at the motion for new trial, where she found that he was incompetent, basically didn't have enough legal skill to represent himself, that is not a proper basis for denying someone their right
So your
to
friend on
represent
the other
themselves.
side, though, says that the trial court, paraphrasing, intimates that the trial court had no duty to act on March 8th. when the request was raised again through council. Do you agree with that?
I would disagree with that. I think that the best course of action, or the gold standard,
Not the best,
if it were
what
to
the
be,
law requires.
well, what the law requires then is that at March 8th, the trial court should have taken up Mr. Perkins' request to represent himself and made at least some sort of finding on the record about the timeliness, whether it was a clear and unequivocal request to represent himself, and whether it was a knowing and intelligent request.
Are you saying that that's true in any time a defendant renews some sort of motion, or are you saying this because of his constitutional, or are you saying this because it's a constitutional question? So what I'm saying is,
Yes.
there's a motion to suppress or a motion in limine that we hear 6 months. We get to the day of trial. Your Honor, we'd like to, my client has asked me to renew our motion to suppress whatever reason. And the trial court says, I've already taken it up, I'm not hearing you. That's probably okay. Or is your argument is because I want to represent myself, the trial court has to conduct a new hearing?
I think under both of those circumstances, what the proper finding by the trial court would be is that is an untimely motion. To raise something like that should have been taken up well before trial, to raise it on the day of trial, that's not proper. I think that also could be something that could be said about the March 8th invocation here.
So I guess then that's the second part of my question then would be, though that's not what happened necessarily here, can we say that was untimely, so it really doesn't, I hate to say it this way, matter what happened in March, because it was untimely?
What about the effect of the state's concession?
Taking the state's concession into effect, I don't think that this court could make that same finding.
Are we bound by the state's concession?
I don't think so, but I think that it does weigh heavily on whether or not this court should step outside the bounds of that and make an independent finding as to the timeliness of it. If this court chooses to do that, I'll be honest, I don't know whether or not that would be proper.
It wouldn't be, right? All other things being equal, because typically our cases recognize that the defendant cannot raise the right to self-representation on the day of trial.
That's
right?
correct, Your Honor.
Typically so.
And there are plenty of cases that would provide more than enough support for this court to find that an invocation made on the day of trial is untimely. So I do think that would be an easy step to make for this court. I do think that this court could also say, considering everything, that the trial court should have done a proper analysis of this second invocation. But just to wrap it all up, even not considering the March 8th invocation, on September 8th, the trial court still unconstitutionally denied Mr. Perkins his request to represent himself because it based its decision on his inability to have, or his lack of any technical legal skill. And that, full stop, this court, other courts have said time and time again, is an impermissible basis. And because of that, we ask this court to vacate and remand for a new trial. Thank you.
Thank you, counsel. Thank you, sir. Thank you, both sides. Very good briefs, very good arguments this morning. And if there's nothing else this morning, we'll stand adjourned.
Nothing else, Your Honor. All rise. This court is now in recess.